with a request from Ms. Alexander?
Yes.
With all the authorizations that you gave, was the authorization that was the request that was made by Ms. Alexander consistent with the instructions that she had been given by you, as well as the documents she needed to sign?
That is correct.
Do you have any question that what Ms. Alexander was doing was relying upon what you, as representative of the Sheriff's Office, implementing Judge Daniel's order, or telling her were the rules of her confinement?
Yes, sir.
Do you have any question that was that way?
You request things of me, I say yea or nay. I refer to the court order and I give my decision.
At any point, did Ms. Alexander disobey any instruction that you had given to her?
No, sir.
At any point, did Ms. Alexander not comply with any direction that you had given her from the beginning of her supervision?
No, sir.
At the time on this past Monday, was Ms. Alexander, in your opinion, compliant with all the conditions of her bond?
Yes, sir.
And when somebody isn't in compliance with conditions of bond, what do you do in your normal course of action?
First, I alert my supervisor, then I alert the home detention officers and the sergeant, and let them know what I believe is going on, and that they need to contact them and bring them in immediately. They bring them in immediately, and they're put in the cell, an investigation is done, a DR is written, and it goes from there, which I've done many times.
And you did not do that in this case, is that correct?
No, I did not.
And the reason you didn't do that is because Ms. Alexander did not violate any of the conditions of the bond that you had instructed her were the conditions during the course of your supervision. Is that correct?
That is correct.
Now, obviously, there is a difference of opinion as to whether your judgment was correct or incorrect. Is that right?
That is correct.
And in exercising your opinion, okay, in exercising your discretion or your belief was an honest belief, correct?
That is correct.
It was made in good faith, correct?
That is correct.
And was intended to allow Ms. Alexander to rely upon it. Is that correct?
That is correct.
And you believe that all of her trips were in fact in reliance upon the good faith decision making that you made. Is that correct?
That is correct.
And certainly, if there's a disagreement about any decision you make, the normal process is either the defense attorney or the prosecutor will come to you and say, we think what you're doing is incorrect. Is that right?
Yes, it happened many times.
And if that situation is that you're misinterpreting, they disagree with the way you're interpreting the order, they have a difference of opinion, the procedure in this courthouse, in this county, has always been, in your 17 years, to have the parties meet, to try to work it out. Is that correct?
To amend the court order or to remove them.
And if that situation occurs and the parties can't agree, the remedies go back to the judge and say, Judge, we have a disagreement. Can either we amend the order or can we file a motion to do something that might change the conditions? That didn't happen in this case.
No, sir.
Instead, what happened is that you were subpoenaed to come and testify at the state attorney's office. Is that correct?
That is correct.
That ever happened to you in your 18 years before?
Never.
Did you believe when you were subpoenaed, did you know why you were being subpoenaed?
I thought I was going to just talk to the assistant state attorney. I didn't know that I was going to give a sworn deposition. I had no idea.
How'd that make you feel?
Objection. All right. Stay on the issues.
Did you believe, based upon the question that you were asked during the course of that statement, that you had intentionally made any wrong decisions in your advice to Ms. Alexander?
Objection again, Judge. Her perception is wrong. Sustained. I think I know the answer to the question right there. You covered this one, okay?
Judge Epstein.
Sustained.
So, I have just one moment, Judge. You were first made aware that there was an issue related to Miss Alexander approximately when?
I'm going to need you to repeat the question, please.
Right. You first became aware that there was an issue concerning Miss Alexander on what date?
It was a Friday, the 20th. A phone call came in saying to leave her home. And I believe the officer that answered the phone said yes. I was looking at it on the screen now.
That'll be December 20th, is that correct?
Right, in late afternoon.
And then on December 23rd, you came in contact with the representative of the state attorney's office, is that correct?
That is correct.
And what was the purpose of that?
He wanted to speak to me about Miss Alexander.
And did you have a discussion with him about that?
Yes, I did.
And did you inform that, and who was that person, do you know?
Richard Manti, incorrect as far as the pronunciation of his last name.
Well, Mr. Manti is the prosecutor.
Yes,
He saw you.
Manti, okay.
He saw you on the 23rd of December?
That was a Monday.
My question was it Mr. Manti?
Yes, it was.
Okay. Now, do you recall seeing an investigator from the state attorney's office?
Yes, I do.
Was that on the 23rd?
No, that was, I don't remember what that was. Hold on. This one has, all right.
Just if I can ask a leading question, refresh your recollection.
You've been asking leading questions for the last 20 minutes, so I don't know where to stop now.
Well, it's cross-examination.
I understand.
Well, this one came, I'm not familiar on the exact day that he came to subpoena the file.
Would that be a Dave Bislenhoff?
Blizzard.
I might be mispronouncing.
Yeah, Dave is his first name.
And did you discuss with Mr. Dave what was going on from the standpoint of your judgment calls related to Ms. Alexander's bond?
Not really. He just basically wanted a copy of the file, and then I pulled up the screen in my office. He wanted to know what that was, and things like that, and I told him.
And then subsequent or after that contact from the state attorney's office and looking at the file, have you in fact made different decisions or changed decisions concerning future authorizations related to Ms. Alexander?
Yes, I have.
And what have those changes been?
She cannot go pay her bond. She cannot pick up or drop off anybody. She cannot do anything in a sense unless it's dealing with the child's in her custody, and it's a medical, and basically just medical for the child and herself, and coming to see me, going to pretrial services, and coming to court.
And so those changes, if you will, not if you will, those changes have occurred subsequent to December 23rd, is that correct?
Yes.
And has Ms. Alexander complied with all those subsequent changes
Yes, she has.
in the authorizations and the requests, is that correct?
Yes, she has.
And the approvals, rather.
Right.
So she's still free to request anything she wants to request, is that correct?
That is correct.
But what you have decided is that you are not going to do any approvals other than within the context that you just described, is that correct?
That is correct. Herself, the children, that's it.
And so any decisions that were made before that time by yourself were decisions that you believe were correct, that you testified to.
It's true.
And you still believe they're correct, is that right?
Yes.
However, based upon the scrutiny, if you will, or the questions are asked, a judgment call was made that you were going to not approve things that you had previously approved, is that correct?
That is correct.
And Ms. Alexander has complied from day one up through this morning with every single condition of her bond, is that correct?
Yes, sir.
And anything that she did that might be considered inconsistent with Judge Daniel's order was based upon your authorization that she could do that. Is that correct?
That is correct.
And I move exhibit 1, 2, and 3 for identification of evidence. I know the questions.
No objection?
No objection.
Are you finished?
All right. Converge. I'm going to ask you to look at exhibit 4 for identification and ask what that is.
These are, excuse me, these are progress note pages.
And these reflect decision-making that you had done during the course of your supervision, is that correct?
That is correct.
And the bottom is the December 20th request, is that correct?
That is correct.
And that reflects things that were being requested on that day that are part of the written request, is that right?
That is correct.
And that has your approval at the bottom, is that correct?
Yes, my initials, yes, sir.
And that's consistent with all the process and procedures we've already discussed, is that correct?
That is correct.
Thank you. I have no other questions.
Redirect?
Yes, sir. I have the defense exhibit 1, please. Did you want number 4 in evidence?
Yes, sir.
It'll be entered into evidence.
Ms. Wilson, would you go ahead and look at, do we have defense exhibit 1?
Should be on.
Madam Clerk, we have it.
Let me see. I'm
You
sorry.
have it. Absolutely. You ready to proceed?
Yes, I am.
Ma'am, would you go ahead and read us paragraph number 1 in defense exhibit 1? That's the exhibit that you had previously been asked to look at paragraphs 8 through 13.
To abide by the terms and conditions of the home detention program is required to court's order in, something's left off, respect to include reparation and restitution.
Every respect, is that,
I'm sorry, it's not on here.
understand?
Okay.
You're familiar with that form?
Yes, I am.
You normally say in every respect?
Yes, I do.
Okay. And that's line 1.
That is
Comply with
correct.
the court's order in every respect.
That is correct.
You mentioned to Mr. Zimmett, and I guess we didn't get into it, your background. You are not a law enforcement officer or have law school training or anything like that, right?
That is correct.
Okay. You mentioned to Mr. Zimmett that the trip to the supermarket was to get a money order to pay the supervision fees, right?
Yes.
Paragraph 29 of Defense Exhibit 1 indicates that those fees can be paid at a kiosk in the center itself by cash, debit, credit card, and there's also the ability to pay it on the internet. Am I right?
No, sir.
That's not what paragraph 29 says?
It says that, but they cannot pay their home detention fees by kiosk. It goes into their commissary account. Budget calls us and asks us to not, people were paying it at one time through the kiosk. Family members were coming and paying it through the kiosk and everything. And budget said they're $500 behind, they're $800 behind. And we found out that the kiosk was not registering their money, so they cannot do that.
So this thing you have her sign, that paragraph is not correct.
As far as the kiosk is concerned,
Any other parts of it that aren't correct?
I would have to get my glasses out my purse and go word to word, sir. I'm sorry.
Do I understand, and let me clear up one other thing. The first time you met me was when?
I'm sorry, number 29. I don't have 29. I just have 1 through 8.
Are there more than one page in that sleeve?
Yes. here it is.
You
Thank you.
see number 29?
Now I do, yes, thank you, sir. Oh, yes.
Okay.
Yeah, this needs to be taken out. Okay.
Back to the other question. The first time you met me was when you came to give your sworn statement?
That is correct.
And Mr. Zimmett asked you if that was December 23rd. It wasn't December 23rd, was it?
It was a Monday.
It was just earlier this year, right? Like a week ago.
I'm sorry, yes, it was, what day was it?
We'll stipulate it's January 6th.
Okay, yes, thank you.
So when you testified before that it was December 23rd, that wasn't right?
No, I'm sorry, but I don't have all the dates in front of me. I know what I know, but I do not have the exact dates and times. You guys do, so please refresh my memory, because I'm not trying to give anything false.
Did we just do that?
Yes, you did, thank you.
Do I understand correctly that after the discipline law showed up and started asking questions about this defendant's supervision, that after that date is when your decisions about change?
Well, not all my decisions. One of my decisions was I called and made reference to the Lancashire Drive, and I questioned her about that.
Is that the time
Yes,
your decisions?
yes, because I was not aware of who that.
As far as the custody orders and things that you referenced in this case, you've never actually seen them?
No, sir.
All right. You have no idea what children those apply to, or whether the children involved in these situations had any...
That is correct, sir.
All right.
I asked you that, right?
You asked her that?
No, I asked you that, remember?
Right. So as far as you know,
Right.
you've never seen any of them.
Right.
You were just guessing.
No, I just knew there was something in place and I didn't want to violate it.
Well, if you don't know what it is, how do you know whether you violate it?
Because it says child custody order.
Do I understand correctly that when this defendant would call and ask, how many times did you receive requests either in writing or over the phone from this defendant? We cover them all between December 6th and December 29th?
I believe so.
Okay.
I can't be 100% sure.
And every one of them you went ahead and authorized, am I right?
I can't say that because there's phone call conversations that take place, and they may have wanted to. May I explain or no?
Sure, please.
A lot of times their pretrial service day is called a color day. So the color day is a certain day of the week, and I have people other than her that are on pretrial services. When their color day comes, I allow them to come down on the it's right around the corner. And so I don't know if she was trying to do a color day and I said, why don't you do the color day and come see me at the same time, things like that. So I didn't authorize everything.
When we first started this, I told you I wanted to talk about just times that
Oh,
she was not coming to
okay,
see
I
you.
got it, okay.
So other than that, you authorized everything she asked for.
Yes.
And then she stopped asking. After the 20th, she hadn't asked again.
No, she asked to come down to the divorce. Oh, I'm sorry, divorce, right? No, right, sorry, right again.
Okay, so you haven't been in. Other questions?
All right, you may step down. All right, we'll take care of this. Do you have any other witnesses or evidence you'd like to present?
No, yeah.
Is there any evidence or testimony the defense would like to present?
Just have one more.
Okay. No, you're, she's accepted. It's all right. You can take the
No, sir.
All right. Let me hear argument from counsel.
Honor issued a very clear and specific order that no one really could be misled about. That order said, you shall be on home detention and you shall not leave your residence except for these things. I think the testimony has made clear that none of these excursions that we have talked about were related to any of those exceptions in Your Honor's order, and I think the court perceived it quite clearly in your own question. Ms. Alexander had anybody available. In fact, the witness even said she had people to go do these things for her. There was no reason she had to personally do any of this.
When did you all find out?
That would be December 20th, Your Honor, which coincidentally is the last time the defendant asked to do any of it. And once December 20th happened, which is when the defendant showed up at the victim's brother's house, among her other list of errands, our detective went over to that office, and the following Monday, that was a Friday, the following Monday...
There's no evidence that's been presented to the court that there was actually any contact between the defendant and the victim's brother.
Correct.
Your understanding as well? You don't have any evidence?
I don't know that there was no contact between her and the brother. There wasn't any face-to-face contact as far as I know. But if the question is there evidence that she had contact with the victim, the answer is no. No,
Well,
there isn't, but the order...
I didn't hear anything in from the testimony that she even came into contact with Mr. Gray's brother either. It was his wife, and she's the wife's friend.
The point of the argument is... Yes, sir. The point of the argument is this. At any of these places, be it any of the public locations, or even this private residence, that potential existed, which was exactly what this court in its order said you wanted to avoid, is the potential for any of that kind of contact. Over and above that, Judge, your order was clear that this is not a normal thing that the court does. This is something that I'm doing special in this case, and I'm giving you extra conditions. That extra condition is spelled out in paragraph 4 in no uncertain terms.
I don't think it was special in this case. It was just the circumstances have changed over the time period, and in analyzing the factors that you're required to analyze in the statute, I felt I could protect the community and assure her appearances at court was something less restrictive than pre-trial detention.
Yes, sir. The phrase that I think Your Honor used was, it's not this court's customary practice, but you're going to do it.
It's not.
And this defendant took advantage of this counsel. I think the multiple requests, the nature of the requests, and the idea that somehow or other anyone could interpret this as a license to go do whatever she felt like doing is in contravention of what the court explicitly stated in the order that allowed her release. I put it this way too. Having already been on release once before and had that release revoked, this defendant is not some inexperienced individual that doesn't understand what a court order is. That defense really doesn't apply in this situation. I understand it is the defense. The defense is, if there was a mistake, it was all April Wilson's, and this defendant just went along with it. Well, this defendant shouldn't have just gone along with it, if in fact that's what she was doing. The state's position is a little different. I think the evidence showed that this defendant did it as long as she thought she wouldn't be discovered. Having said that, I also made the point that under that theory, had this defendant made any request that would have violated a different paragraph of the court's order and gotten Ms. Wilson to agree to it, she clearly knows there are certain things she can't do. This defendant understands that. She didn't, hopefully, go get a gun or anything like that, although that's a specific separate paragraph of this court's order that's not in the standard little contract that the pretrial services signs. It's not even a correct form, as Ms. Wilson made clear. Not everything even is accurate on it. So she knows. Frankly, Judge, the idea here that the defendant simply keeps misunderstanding This court is relying on her judgment in granting her release. You're saying that you believe that you can satisfy all the purposes of the statute and that she will exercise the judgment to comply with the court's order. Frankly, I think the evidence shows you can't rely on it. This isn't the first time, it's not the second time. And so we put it again to the court. How many is enough? It's not that Ms. Wilson brought this to anyone's attention. It's not that the defendant or any of her attorneys brought this to anyone's attention that she was up doing these things. I don't know that her attorneys even had any idea. I doubt they did. But certainly, the defendant can read English. And she certainly understands, after the lengthy hearings we've had and the multiple hearings we've had in this case, that as opposed to living out and about, she should be living at the foot of the cross. If there's any question, and that's a metaphor, if there's any question about her behavior, it ought to go to her lawyers into the court. There's enough lawyers around. So to simply walk in here and say, well, I found someone who said I could go ahead and do it, and so I just didn't bother to ask anymore, it shouldn't be good enough. It isn't good enough. And the state requests that the court make that exceedingly clear. Thank you.
Response?
Yes, Your Honor, briefly. Your Honor, the court released our client on Thanksgiving Eve. At that point, that very evening, your order was faxed over to the sheriff's office. And what we now have heard from Ms. Wilson, an 18-year veteran of the sheriff's office, was assigned. It wasn't someone, of course, that our client could. And that same day, Exhibit 1, as has been discussed here at some length, became the contract between our client and the sheriff's office. I think it was read to her, I'm sure.
We can all agree that the contract between the defendant and the sheriff's office does not come off this court's order.
Absolutely.
Do you think that somehow my court order is ambiguous? I want to hear that.
No,
if it
Your
is,
Honor.
I'll address it, because certainly not infallible, but I didn't think it was ambiguous. But if there is, I want to know where it is.
I think, Your Honor, I agree that it's not ambiguous, and I think that there's some clarification that we want to put on the record today, we should do so. Even just in an excess of caution, given the links that have been gone to bring all this to the court's attention, and I think there's a number of things we'd like to bring up as well, including, for example, specific permission from the court now for Ms. Alexander in preparing for her defense.
Let's deal with and address the issue at hand.
Of
All right,
course.
whether I should revoke the bond.
I understand.
Before we ever get to additional conditions.
Understand, Your Honor. But just in terms
When
of,
did you all know that this was going on?
Your
As
Honor,
attorneys,
I think we knew this when we understood there was an investigation somehow.
back in December of 20th?
No.
I believe it's December 23rd,
Right.
when Ms. Alexander was called back into the office to meet on the 26th, and Mr. Schultz accompanied her on the 26th back to the office.
Okay, so you all knew about it around December 23rd that all this was going on. What steps did y'all take at that point
From the standpoint of,
to get to the bottom of the issue, if anything, if any steps were taken?
well, we wanted to find out whether she had authorization.
Hold on. Everyone's cell phones need to be turned off. All right? I hear another cell phone over. It is. I don't care if they're in the media, they'll be asked to leave. Continue.
We want to find out whether or not she had authorization for any of the trips that she had gone on. We found out that she did. We also learned that because of the investigation, a decision was made that authorizations that had occurred previously were not going to be occurring in the future. So there was no additional steps that would need to be taken, since what authorizations had been made and relied upon had already occurred. It was something that we believe, quite frankly, was a step that should have been taken if there was an issue, to make sure it stopped if something was done that should not have been done, and to move forward without it happening.
Well, do you feel it should not have been done based on the court's order?
I'm
I'm asking you to be very candid.
I'll be candid, if I was in Ms. Wilson's position, I would have asked for help, and I would tried going to the court to see whether or not our standard procedure was consistent or inconsistent with the order. Obviously, your order says what it says. It's pretty clear. What she's been doing for 18 years is different than that. And certainly, the way to remedy that, I would think, or to find out if there was an issue, is to come to the court or go to a supervisor.
Were you all aware that there was this contract, that, obviously it was presented to her when she, came to pretrial services, and she was given this contract with all this language in it. Were you all aware of that?
First time I saw it yesterday, when we started.
But certainly, Your Honor, to supplement that, her instruction, our client's instruction, was to be in constant touch as required with the designated sheriff's office. Whatever they said was the rule. That was her conduit with the state, and not certainly the prosecutor, not the court, not us, but that was her contact. And if there was any issue, any question, that was the person to call. That was the person to put on her ankle monitor, and that was her boss. And those were things we didn't know about the contract, but those were the instructions we gave her. And, Your Honor, I think you understand our position on this, which is that there's never been any conduct in terms of seeking to see the 3 alleged victims, Rico or his children, trying to see them, getting close to them, and the suggestion that somehow going to for example, the eyeglass doctor, she might have seen him there. Ms. Wilton was clear in her notes and in her statement under oath. She gave a deposition that the state required that, for example, when our client asked to go to Lens Crafter, she said, no, I want you to go to a specific place to get the glasses. It's less travel, that it was, in and out of there. That getting the bail bond from Ms. Dudley, the bail bond money from Ms. Dudley was a 2-minute conversation that took place, outside the home. Not only was Mr. Gray not supposed, to be there, there was no plan, no hope, no suggestion that he would be there. So in terms of what the bail statutes require, that there be a combination of conditions that are for the 3 alleged victims here, there's no evidence of even seeking to see them or seeking to get information about them. The only contact that we know of is the interactions in the custody and divorce court. They haven't seen each other there. There's been specific arrangements through a third party that they come in, they don't come in together. One of them appears on the phone, or when Ms. Alexander had to go to court, Mr. Gray appeared on the phone, so they haven't even seen each other there. Custody for the young daughter has now been established as joint. So Ms. Alexander has her daughter about 3 days of every week. It's not quite 50-50, but close to that. But all that has been accomplished without seeing Mr. Gray, and certainly without seeing the other children that she cares about. She certainly hasn't seen them or tried to. So in terms of the 2 big concerns, safety and appearing in court, she's made every court appearance. She's notified Ms. Wilson for every court appearance, whether it's the divorce proceeding or being here. The conditions that have been put into place have been sufficient, and there's no suggestion of a violation of that. So in summary, she has complied with her state minder to the T. There's no suggestion she tried to get a specific state official to, be on her case. She's the one that was assigned to her. There have been, multiple weekly calls, visits. There's been no contact, no emails, no anything with Mr. Gray or his children. So the bond statute still applies, and the preferences for, for release under very onerous conditions. And we suggest, Your Honor, that if there's any clarification that needs to be made, we're here, we're ready to do it. We believe it should have been accomplished informally with the state, but we certainly can do it here. Thank you.
Mr. Short, you stood up 3 times now. Is there something you need to add?
Only to say, Your Honor, excuse me, and it may not even be appropriate or necessary, but I think to emphasize the seriousness of the serious response once we became aware that on the 23rd, Mr. Bisbinghoff went to the office. we, as did pretrial services, Ms. Wilson, Ms. Sizak, her supervisor, and others, reacted immediately and imposed, provided further advice and direction, frankly, to all of us. Early in the morning, right after Christmas, I met with Ms. Alexander and accompanied her to Ms. Wilson's office. When the person I met, Ms. Wilson, was a dedicated, educated professional, had respect for the court, had respect for the laws, had respect for the office which she served. And I believe, Your Honor, certainly we all live and learn. We have learned. And I humbly, Your Honor, request that we allow, the court allows, Ms. Alexander and all of us to learn from this experience. And we assure the court that we will abide strictly. We just ask the court to give her the further opportunity to live as normal a life as she can during these unfortunate circumstances. Thank you.
All right, rebuttal, reply.
Briefly, Your Honor. How many second chances before they're not second chances anymore? We've heard this, I'll behave. The behavior in this case is I guess, once it's being put on it is, we learned we were mistaken. The other answer is to behave like the person who got caught with their hand in the cookie jar. And I think that the court can fairly attribute to this defendant, in view of the history of this case and this particular defendant's behavior, which is something that you can consider and you're well aware of, is, by my count, at least 9 coincidences too many. 9 times, 9 separate days in a 2-week period, this defendant felt entitled to ask because she knew someone would grant it, because that someone never once denied a request. Never once. To go out and do and act as a person who is not under those restrictions. It's that simple. And frankly, had the state not brought this before the court, I'm not sure the court would have ever been told. That's why we're here. Thank you.
All right. I had a lot of questions before I arrived here today. There were submissions that were given to me before today, and it's very clear to me what happened. All right. This is a situation that has occurred because of a mistake. Simply that, and nothing more. There was never any discretion given to anyone under pretrial services to interpret the order. And it's, as everybody has agreed, it's pretty clear. You stay at home, unless there's one of these few narrow circumstances. That didn't happen. Why didn't it happen, though? In my opinion, was not a willful violation. All right, I've heard the testimony and the evidence here. There's no evidence that the defendant sought out to get an interpretation of this order favorable to her so that she could go and do the things that she was prohibited from doing under the order. In fact, the first thing she was presented when she arrived at pretrial services was a contract that said that she could ask for permission. The contract was a nullity. There was no authority to have, for her to sign it and somehow that trumped the court's order. It was void, nullity, whatever it was. But I understand that's what the common procedure was by pretrial services and the community, I guess the CTC, who do a lot of valuable work for us here in the court system. It's their customary practice. I wasn't asking for them to do their customary practice, and I will make sure that that's specified in a supplemental order, so that it is very clear that nobody has the discretion to allow Ms. Alexander to go run errands, no matter how benign they may be. The intent of the order was for her to stay at home, period, unless there's a medical emergency, come to court, all right, or the PSP, the Pretrial Services Program, or the CTC needed her to come in, whatever requirements they had. It was a mistake, and they happened. Okay? Not a willful violation. This is not giving a defendant the authority on pretrial release with the bond and conditions. I don't think she's willfully violating this. If she did or does in the future, this would be a much shorter hearing, and she would be remanded in custody, period. But I don't think it's a willful violation. So, we're going to go back to square one. We're going to put a supplemental order in place where it says that there is no discretion for the defendant. No one has the discretion to authorize the defendant to leave under any circumstances. This court is the only entity that can enter those orders. And I will entertain those orders, or entertain those requests from the attorneys in a hearing or informal hearing is notice to the other side so that the other side can be heard. I had some real concerns about who knew what when. Those questions have been answered. Defense counsel obviously didn't know. It appears to me I'm satisfied, and I believe it's credible. They didn't know what was happening, and they found out after the state learned what was happening, and appropriately went over to investigate what was happening to get to the bottom of it. The defense got with their client, put a stop to it. Everybody backed up and went back to square one, and that's where we're going to start again. All right. So with that, I will be on a short list for denying the motion. Now let's talk about issues in the case and getting this case ready.
Yes, I mean, just, Your Honor, one point of clarification in terms of that.
Don't touch it. It might,
It just bit me, so that's okay. In terms of the one modification we would ask, and certainly we can do it with notice to the state or however the court would prefer us to do it, it's just as we are heading towards trial, we would like to be able to meet with our client in Mr. Schultz's offices at Holland and Knight. Would you like a written request on that, or?
Yeah, you all mailed something or contacted my assistant requesting that. That's earlier this week, which kind of I found curious because in the order it says she can go to her attorneys. Mr. Schultz has entered an appearance as one of her attorneys.
We understand that, Your Honor, but just in terms of the fact that there has been confusion and a mistake here, we just wanted to be clear with that on the record.
That's fine. Yes, she can go to Mr. Schultz's office to consult on her case. All right?
And that is sufficient for us because we'll all meet there together. Thank you, Your Honor.
All right, let's talk about where we are. Maybe somebody might be able to provide that information to me as far as getting the case.
Judge, we have a trial date set for the end of March. My understanding is I haven't received any new witness list nor background evidence. I don't know if there's any additional discoveries. I'm sure both sides will have some pretrial motions.
Well,
We may want to set a date now for both the filing motions as well as the hearing date. But that's really the only item that the state's going to do.
all right, what motions?
I think there'll be, generally speaking, legal argument only. I don't anticipate any necessary evidentiary hearings. I would expect that there will be some discussions about jury instructions, since that was the central point, as well as limited testimony from certain witnesses, reputation type stuff, that sort of thing.
There's a lot of orders that were entered the first time.
Yes.
You were involved in the case. Your co-counsel was, Mr. Thompson. There's a ton of orders already out there.
Yes, sir.
Dealing with reputation testimony and what can come in and what can't come in and that type of thing. Now, I don't know if there's some more that's been developed since in the interim, since
complicating the immediate has heard today, there is this ongoing Exhibit 9 for agree on just have a day in our minds, which we will have all these issues before the court. So
I'm pretty liberal in granting the pretrial conferences as the attorneys need them, and I would make an exception in this case.
Judge, if I can make a suggestion, maybe if Mr. Mantine and myself can speak and come up with a pretrial schedule and order that we could agree upon and submit it to the court, and then see the available dates for possible hearing dates and so on. If that might work. Maybe we can just have a filing conference once we get an agreement.
All right, I need to hold on a second. We've got it. I just got to do that for my system. Is there a Kumasi errand in this courtroom right now? All right. My understanding is that there were, we're going to deal with that, but I need you to stay after the hearing, all right? Okay, thank you. Let's continue.
The suggestion was that Mr. Mantine and I try to come up with a pretrial schedule and order, and then go over those dates and see what we think might be necessary hearing-wise and work with the court on available dates, if that works.
Well, I mean, my sole interest in all this is making sure that this case is on track. All right? I don't know what you're doing. I like to find out at least pretrial conferences what you're doing and what you intend to do. I don't know. We tend to have obviously gotten with the hearings such as this, but are depositions been scheduled, or are you scheduling those now? What's going on?
We are doing our investigation, getting ready to identify what witnesses we think should be deposed. We want to look at prior witnesses that have been deposed and see if there's any areas that have not been previously deposed, see if that's appropriate for depositions. Any new witnesses, obviously if the state has new witnesses, we'll want to depose them. We will have...
How many are we talking about?
State witnesses?
Yeah, new witnesses.
I don't know.
there have been no new witnesses. I think he's
Saying,
You're guessing.
if there are going to be.
Well, I would assume if there were new witnesses that the state knew about it, they would have already disclosed those to me at this point under the discovery obligation. So, it doesn't appear that there's any new.
I think it is the only potential witness would be an expert of some sort, but not so far.
And we're in the process of speaking with experts, Judge, identifying them and trying to allow them to do their work and to make the proper notification to the state of who they are and what they would say so they can set them into that position to choose. We're not finished with that process yet. We also believe that a jury questionnaire will be appropriate in this case because of the publicity. We want to try to work through the mechanics of that and would be wanting to speak with the court as far as logistics and procedure. I don't know if the court has utilized them in past cases or not in Jacksonville.
Questionnaire?
Yes.
No, I don't. I find that they take as much or more time than is necessary. I mean, when I can just simply, ask individual questions of the jurors that have indicated they have knowledge of the case and that type of thing. But I'm open to listening to from both sides.
And so, one of the issues with it is, can we get it to veneer prior to the time of them coming to court, so that logistically, so we can have that digested.
You're not going to know who the court's office, and you're not going to know who would be selected to come up here. All right. I don't know if the court's office could make some special consideration or whatever as far as identifying who might be in the pool, well in advance. I suspect they probably could. I don't know whether it's necessary or not. Okay, and we're going to discuss some of those things. I'd like to have more frequent pre-trial conferences to discuss procedures and get your input from both sides as to what y'all want to do. And obviously, I have my own thoughts, but certainly.
I'm sorry, Judge. Obviously, with the publicity with the case and so forth, we don't want to be selecting a jury if someone staff off something that taints the rest of the panel. So obviously there are steps, including a questionnaire, that can potentially alleviate that and give us a little more comfort that we're not going to have a tainted panel and we can in fact get a jury.
Well, I clearly anticipate that there will be a lot of the jury selection process done with individualized questions that about the case or say they have something about the case.
Sure.
So the general question in front of everybody about what they think about the case. That's not my intention. Okay. My first February, start talking about some of those issues. What is your schedule? And understand there are 3 attorneys, and obviously, if only one can be here.
Judge, I probably anyone.
Anytime of the week, if they were on docket, Monday through Thursday.
Is there a better day, Judge, to schedule us with? Calendar, that there isn't as big a calendar that...
No, the docket's going to be docket, and it's going to be anywhere from 40 to 60 cases.
Yeah, one second, Judge, check this. How about Wednesday the 5th, Judge?
That's fine by me. Well, probably would want to do this. Can you all be here early? Because I'll just handle it. Because this case usually brings a number of people in with it. Maybe start good at 8:30.
And Judge, we'll try to work on a proposed schedule before then, so we will have it to give to the court.
All right. Why don't we shoot for 8:15 on the 5th for the pretrial conference? Okay. We'll discuss scheduling a little bit more, depositions, and start talking about some of the issues. Okay.
Yes.
All right. Is there anything else that you all need to discuss or pretrial conference?
No, sir.
Oh, you're on.
Okay. All right. I need to see counsel Sawyer over here with the court order. All right. Well, I'm getting ready to do that. If some of you are choosing to leave right now, rooms, and you just can't that up. Okay, so just please, if you'll respect that, we won't have problems, and the sidebar. And Ms. Wilson, you can stick around too for a few minutes. I appreciate it.
What I can do online.